The concept of registration or regulation is often touted by members of the translation and interpreting industry as a solution to many of the problems we experience. This paper examines the failure by most people to define these terms, then defines them, and then shows what political and practical barriers exist to the implementation of strong regulation, puts arguments as to why such a regulatory regime would be wrong for the industry, and finally argues that what is possible and desirable is already being actively developed by AUSIT. Registration is a word beloved by people in this industry. One regularly hears that we must have registration and when registration comes in and so forth. The word needs a strict definition. Registration means there's a register, a list of names. Generally, you have to do something difficult to get your name on the list. Be educated, pass a test, obtain a qualification, for example. Then you can have your name taken off the list for failing to do something or doing something wrong. There are certain things you can only do provided your name is on the list, and you can get punished if you do those things when your name isn't on the list. That's what registration means. It is a very popular word in this industry, and this is probably helped by the fact that it appears in the constitution of AUSIT, the peak industry body. To work together with NAATI and relevant authorities for the establishment of a national registration board for interpreters and translators, together with appropriate enabling and restrictive legislation, including a system of licensing. There are more relevant words here: legislation and licensing. We are all, of course, familiar with accreditation, and recently the idea of certifying practicing interpreters and translators has been discussed. But all of these words too have strict meanings. For example, certification means giving you a bit of paper that says you've done something in the past. In other words, proved that you are capable of doing it. Licensing refers to a bit of paper that says you are allowed to keep doing something until a particular date, and implies that there is a mechanism that can prevent you from doing it under certain circumstances. All of these things, and many more, are regulatory mechanisms. These mechanisms, in various combinations, constitute regulatory regimes that apply to some human behavior. Regulation is the overarching heading for these things, and that is the main subject of this paper. There are regulatory regimes for many different activities, each consisting of different combinations of regulatory mechanisms. Regulated activities include driving, working at a kindergarten, umpiring a junior basketball game, practicing law, voting, preparing and selling food, selling prescription medicines, owning guns, and so on. When people in this industry use the word registration, they use it as a synonym for regulation. And I believe that they imagine a regulatory regime that includes significantly a registration board, legislation, and some system of penalties. I could be wrong about this. To my knowledge, no one has actually defined, in practical detail, what they mean when they use the word registration. Strangely, this lack of a definition has not stopped many people from saying regularly that we simply must have it. In this paper, I call this type of regulatory regime that includes a registration board, legislation, and a system of penalties strong regulation, and registration would be just one of the regulatory mechanisms in that regulatory regime. Today, I will argue that strong regulation for the interpreting and translation industry has no prospect of realization, but that a lower and more desirable level of regulatory effect may still be achievable. At the Ministerial Council for Immigration and Multicultural Affairs, a Commonwealth State Forum of Multicultural Ministers, in 2002, regulation of this industry was comprehensively rejected by the state and federal governments. I have tried to obtain the details of this decision through the Freedom of Information Act. Unfortunately, I was not able to do so by the time of this conference. It is thought, however, that difficulty of ensuring uniformity between the states may have been one of the reasons for their rejection. It is perhaps more sensible to assume simply that as a candidate for regulation, translation and interpreting simply failed to meet the criteria for regulation that governments have laid down, which are that in the absence of regulation for a particular activity, a small number of people are at risk of significant harm, or large numbers are at risk of moderate harm. In other words, the government has to see a problem to which regulation is the only possible solution, and they didn't. Immediately following the presentation of this talk, I was advised by a person in the audience who was present at the meeting in question that the real reason it had been rejected was purely political, in that deregulation of various industries had recently taken place and that it would be incongruous for the government to be seen to be introducing more regulation. There was no expression at that meeting of an understanding of the issues any more sophisticated than this. And subsequent to this paper being presented, correspondence was received from DINIA, a response obliged by the Freedom of Information Act, where they said they must decline our request for the documents as they were destroyed in accordance with departmental guidelines. Now, people may hold the view that governments don't see much, and what they do see can be influenced at the ballot box or through lobbying. And so some may retain hope that this policy may one day change. But even if things did change politically, here are some more problems. The first difficulty is designing and implementing regulation that actually does what you want it to do. Insofar as a regulatory regime may seek to prevent something from happening or seek to allow a certain thing to happen only in certain circumstances, there must firstly be a good definition of that thing. Good means capable of proof. It must describe something that either happens or doesn't, and which leaves some sort of evidence we can use to verify that it happened or not. Furthermore, the definition mustn't include things by mistake which we don't want to regulate. Even in medicine, which is regulated very strongly and to which we often look as a model of strong regulation, this is extremely difficult to do. No exhaustive definition of medical treatment is mentioned anywhere in the legislation for the purposes of regulating doctors per se. In fact, it's good policy to leave the definition open to contest so as not to impede the progress of medical science. Recent court decisions on whether the delivery of food to a brain-dead person constitutes medical treatment illustrate this. The most powerful regulatory mechanism for doctors is indeed registration. The law does not seek to define what doctors can do, but simply who can call themselves a doctor. Specifically, you are not allowed to advertise as a registered medical practitioner unless you are one. But what is the regulatory effect of this? In practice, people are more often prosecuted for the offences they are able to commit by virtue of their masquerading as a doctor, such as fraud or sexual assault. It's unlikely you'll be taken before a magistrate simply for telling a girl at a party that you are a doctor in the hope of getting her to take her top off, unless it works. The important feature of this that must be highlighted here is that it is the ostensible provider of the service who is punished. In medicine, there are several categories of such a party. A person who is studying but not yet entitled to hold themselves out as being registered medical practitioner, somebody who has studied and failed, somebody who is registered but only for a special area, someone who's been deregistered for misconduct or malpractice, and the very hardest case of all, which is the most relevant to the topic of regulation, and that is someone who has never even remotely studied or tried to become a doctor. A person who appears out of the blue and pretends to be a doctor. Even in this case, our society finds it appropriate and reasonable to punish that person. The practicality and viability of legislation that seeks to punish a person in this way relies on the well-established understanding within the community that there is such a thing as a doctor and you either are one or you aren't. It is well known that no such understanding is established at all in the community with regard to translators or interpreters. This is widely and correctly acknowledged to be one of the biggest problems that this industry faces for a variety of reasons, but in this instance It clearly makes such legislation impossible. It may be argued that by introducing such legislation that understanding could be established, but this would inevitably mean that in the months, years or decades that such establishment would take, blameless friends and relatives would have to be punished. Blameless because they simply didn't know that they weren't meant to be interpreting. The likelihood of such legislation being introduced is slight. Another difficulty is this. It's not just this list of people we are trying to regulate. We are actually trying to prevent things from happening in the complete absence of an interpreter, real or pretend. This is not like law or medicine. If people can resolve their disputes amicably, that's a good thing for everyone, except lawyers. People can discover the secret to good health, taking the herbal remedies at their own risk, and if their doctor never hears from them, society is not offended. But our situation is a little like that of plumbers. Unless you have a licensed plumber carry out all your roofing and drainage work, your house will not be issued a certificate of occupancy, which will make it impossible to sell. In this case, the law has found a strong regulatory effect without having to punish the unlicensed person who did the plumbing work, whoever that was. We need something like that. It would be a pretty poor regulatory regime if it permitted magistrates and doctors to do without an interpreter altogether, just by yelling. And yet, if we supported regulation that only sought to punish those who either were registered or otherwise to provide the service, such as the model bill prepared by Nati in 1991, and if it was effective, we would be causing an increase in the incidence of people trying to get by without interpreters at all. We'd be shooting ourselves, our whole industry, in the foot. Because users would often face a choice of someone unregistered and unwilling to break the law, or no one, for which there was no penalty. Could we blame them for choosing the latter? We'd have to blame ourselves if we'd stood by and let such a state of affairs come to pass. A little while later, I will be mentioning the term self-regulation. Clearly, self-regulation would not be a solution to this either. These issues force us to envisage a regulatory regime where, rather than the provider being punished, certain settings are defined with certain responsible parties present and they would be punished. Police, judges and doctors would be told off for not using an interpreter. We currently have a regulatory regime, though it is clearly unsatisfactory to many within the industry. It's a weak regulatory regime, but it takes the form described here, where people other than that practitioner bear responsibility for the provision of the service. More specifically, it consists of non-compulsory training and accreditation of practitioners, and whatever awareness of this system of accreditation and training and policies that refer to that system among hospital administrators, doctors, police and magistrates, and the value that they attach to it as an indicator of ability. Sometimes accreditation works as a specified or preferred standard of purchasing of translation and interpreting services. And this may be set out in a purchase agreement by which a supplier might be bound. All of these things have some regulatory effect. This form of regulatory regime represents a philosophical challenge for us because it is a model that hands ultimate responsibility for regulation to people other than practitioners. But putting our emotions aside for a minute and thinking practically, we must acknowledge that the conditions in this approach are nevertheless the most favourable for success. The senior and responsible person in each of these settings, the judge, the doctor, the interviewing officer, is accountable within a hierarchy that goes all the way to some funded arm of the government. In other words, we can get to them and make them do things. So the regime has the potential to be strong. And furthermore, these settings offer the greatest opportunity for there to be a concrete record or evidence of certain things having been done or not, which is an essential element of any form of regulation. To reiterate, however, this model fundamentally can't seek to punish the innocent unregistered person because it just wouldn't be fair. Ignorance of the law would in fact be an excuse for not making such a law in the first place, because there are just too many ignorant people. But it also has an unfortunate political consequence. Regulation would threaten to materially affect the working conditions of doctors, nurses, police, lawyers, judges. They all have much more power than us. They would have to be consulted, and it is very likely that they would all object to a strengthening of the current regime. Let's go back to the benefits, though. Limiting the scope of regulation to settings involving these people would also be good in that it would exclude things that don't need regulating. That means all work in the business domain, where caveat emptor applies and people and companies are free to spend their money on whatever they perceive to be a reasonable solution to their language barrier needs. Some still speak of regulating work in that domain. The arguments as to why you couldn't or shouldn't are for me too overwhelming and self-evident to waste time on in this paper. Notwithstanding the ambitions of previous OSIT position papers and policy statements, which spoke of the regulation of those who translate poetry, practiced with notable effect in communist China, for example, rather than try to show why these would be impossible and inappropriate things to regulate, I encourage the reader to focus simply on those settings where all the conditions are practically ideal for enforcing regulation. And at the end of this paper, please ask yourselves, if we can't do it here, would we have a hope anywhere else? I examined two of these settings below. The first is police arrest and interview, clearly a setting in which there is the very highest imperative for the state to ensure that interpreting is carried out competently. The current regime is fairly effective in the form of accreditation plus internal policy in, for example, the New South Wales Police Code of Practice for Custody. But this clearly leaves it open to the police to judge whether the use of an unaccredited interpreter or proceeding without anyone assisting is reasonably practical. This is what they call a loophole. In lieu of detailed definitions of the word registration that is used by so many people, I am assuming that when people speak of the establishment of a registration board and so on, they want loopholes like this closed up. Deferring investigation until the arrival of an accredited interpreter might not be reasonably practical for many reasons, but let's just look at one of those reasons, the particular language required. This graph shows demand for languages in the Melbourne Magistrates Court, compiled in 2001. At any point in the future, for purely statistical reasons, the spread of language will always approximate this curve, with a long, thin tail end. There will always be languages which go by a bewildering range of names, rare and emerging, new and emerging, of limited diffusion, etc., for which demand is low and sporadic, and for which there is consequently no reliable supply of interpreters. So one problem of a strong regulatory regime that is immediately apparent is that the rules would not be applied equally. Apart from being a policy issue that would cause problems for a representative form of government, in practice it would be a nonsense to punish police for not using an accredited interpreter if none existed. So some languages would have to be treated differently. Well, which ones? How do we define them? Who gets to define them? The only attempt I know of to define them, and this was like pulling teeth, is to say, well, languages that Ngati don't test for. But as a practical solution to the problem of enforcing this legislation, this is manifestly inadequate. Why? Because just by offering tests doesn't mean people are going to sit them, and just by sitting them doesn't mean people are going to pass them, and just by passing them certainly doesn't mean that they immediately become available for work. And even if they are, it doesn't mean they want to, and just by turning up to work certainly doesn't guarantee that they're going to do a good job. And even if all those things went right, and Ngati offered tests in one of these languages, how many people would have to pass, and where would they all have to live, so that there was one close enough to every police station and crime scene in Australia for there to be no prospect of unreasonable delay in the response time of an interpreter? In one of these rare, new, emerging languages of limited diffusion and urgent need. In other words, one of the languages in which there's no way you could make a living and you'd have to have rocks in your head to choose an address on the assumption you would. We're dreaming if we think that all these details can be worked out by a legislator somewhere. But let's dream on. A list of these languages could be a schedule appended to the legislation perhaps, but how often would it have to be updated? Annually? In response to external events like the Kosovars arriving or tests being discontinued? And what would be the cost of doing this? The reality is that the burden of simply administering, let alone prosecuting someone on the basis of such inconsistent and unwieldy legislation would be prohibitive. And as I have demonstrated above, there are many powerful interests who may oppose any such strengthening of the current regime, who would easily and effectively cite that burden as grounds for their opposition to strong regulation. Let's go back to response time in any language. When police suspect the commission of a crime, they are duty-bound to intervene and make their best efforts to apprehend perpetrators or those suspected of committing crimes, detain them and gather sufficient evidence to bring before a judge in order that the person or persons be punished and the public be protected. And in the course of executing said duties, police are required from time to time to communicate verbally with individuals who are not conversant in the English language. Things can happen very quickly in policing, demanding a rapid response. People must be detained, restrained, pursued, evidence gathered, and the deployment of other police managed. Crime can involve the speakers of many languages, mostly English. They may present as suspects, victims, or simply witnesses, and these claims can be mistaken or deceptive, and this is not revealed until hours or days later. It can be an extremely complicated and unpredictable situation. There is sometimes the romantic notion held up that translators and interpreters are helping those who can't speak English. This is rubbish. Translators and interpreters are helping all of us because they are enabling the processes we all rely on and believe in, such as the apprehension of criminals and the administration of justice. If a non-English speaking person's rights are damaged because of the language barrier, it should offend every Australian, not just the non-English speaking person. In such a situation, with respect, we will all ultimately agree that as long as it is impossible to judge how an act will affect the interests of an individual, the question will be subordinated to matters that can be judged, such as whether proceeding without an interpreter is in the interest of the community. And police must be empowered to exercise that judgment, and that is the position they will take, which means that the regulatory regime would stay as it is now. Another setting on the regulation of which there is general consensus are those conversations between a doctor and his or her patient. Miscommunication during the taking of a history, examination and treatment could cause serious damage to the patient's well-being. Regulation would be a farce if it omitted this setting, and by extension completely worthless if it excluded the second setting I wish to use as an example. The discussion that takes place between a pharmacist and a non-English speaking customer prior to their handing over a prescription drug. I and two assistants approached 20 suburban chemists in Melbourne in areas with high ethnic populations and asked them these 8 questions. How many staff members currently work at your pharmacy and what are their job descriptions? How many customers per day would you have who are purchasing prescription medicines and who do not speak English? What would be the most common languages other than English that these customers speak? When explaining to a non-English speaking customer how to use a prescription medicine, how do you usually overcome the language barrier? When dealing with this type of situation, do you feel there is a need for an interpreter or other translation services? Are you aware of any such services available to you and your staff? Would you consider employing an interpreter at your pharmacy or encouraging your current staff to obtain training in interpreting? Do you think there are significant risks in using untrained or unqualified people as interpreters? If it is the setting that is to be defined, and if we are to rely on the presence of someone bound by other professional or legal obligations, then the results of this survey suggest some more practical barriers to regulation. There's clearly a problem. Obviously, we targeted areas with high populations of non-English speakers, but taking the lowest figure, and at 1 per day, these conversations take place at least 11,000 times a day in Australia. Pharmacists themselves acknowledge there are risks involved in not using a qualified interpreter, although they perceive the risks according to their own judgment. And how good is that? Well, let's have a look at this question. How do you usually overcome the language barrier? The majority of responses were that they employed staff who spoke the language in question. In lieu of that, they believed that speaking slowly and using visual aids are adequate substitutes for communication. One said they pointed to the sun to indicate that a medicine should be taken during the day. The risks were adequately dealt with if they had staff or friends or relatives do the interpreting, although they were concerned about children. Some said they would ring the doctor or their own friends to assist when desperate or in the more difficult cases. A pharmacist is trained in pharmacology, not linguistics, and so their concerns that among non-interpreters children necessarily represent a greater risk, or the assumption that they are qualified to judge which are the desperate or difficult cases, prima facie lack foundation. Overwhelmingly, they said they would not employ an interpreter because of the cost. Telephone interpreting would be the solution. Half were aware of this kind of service but didn't use it because of the cost. On one PBS prescription, the pharmacist makes about $2. TIS charged $21.70 for a phone call. They said they'd use it if it were free. That represents, if we imagine every pharmacy in Australia using it once a day, 260 days a year, an opportunity cost to TIS of over $60 million per annum. Let's imagine that money could be found. We will need really good imaginations. When we approached various agencies to sponsor this conference, On Call heroically provided a sum in the thousands. TIS sent some fridge magnets and seemed to think we would distribute them for free. Anyway, imagine the money could be found. The point is here, how would we know about all the times they didn't ring TIS? We have a group of people who are quite happy to believe that bilingual staff or gestures are an adequate substitute anyway. We also found that pharmacists are busy people trying to make a dollar. Some had tried using TIS before and found it too slow or unreliable. Clearly a risk given the problem of languages of low supply mentioned above. It would only take a couple of bad experiences before their uptake of the new free service would turn down. So we'd spend all that money for almost no regulatory effect. If you tried to come down hard on them, if you told them they would be punished, how on earth would you police it? And what would that cost? It would certainly entail a level of official scrutiny that differed according to the number of non-English speakers in a suburb, a difficult policy to implement in glorious multicultural Australia. And counterintuitively, the bureaucrats would start with the ethnic areas, but there might be a linguistic case for starting with the chemist where they only get one a week, because that's where they'd really stuff up. But I don't see the government bean counters asking our opinion on that one. With this limited time, I have only detailed a few practical barriers to a strong regulatory regime in two settings. Some of them, I'm sure you can see, also apply regulation of interpreting and translation that involves doctors, lawyers, courts, banks, and so on. It would limit police powers and increase their workload and responsibilities in ways for which they are not trained, such as identifying those languages most difficult to identify, and as a piece of legislation would oblige them or people they engaged to act as interpreters on an ad hoc basis to break the law by using or being unaccredited or unregistered interpreters. Pharmacists would oppose it because it was an impediment to business and unfair, punishing or creating a burden for them because of their location in centres of ethnic population. All of this is ammunition for people opposed to the introduction of such regulation, and they would leap on all of it and use it to prevent regulation from being introduced. Indeed, there are several levels of checks and balances that must be passed before legislation is even drafted, and it would be a pretty lame state or federal government that was unable to dig up all the practical issues and more than I was able to find in my spare time. Let's make a further assumption that all of these problems could be overcome. The next problem is a very simple one. In arguing for regulation, practitioners are sometimes their own worst enemy. In the recently released report by Dr. Aldous Oslands, the most talked about result of which was the overwhelming support among practitioners for some regulatory system, the 40 quoted survey responses used to illustrate this included exactly 20 comments expressing the benefits of regulation as either an improvement in pay and conditions or the ability to weed out the bad apples. As a weapon to lobby for regulation, the publication of comments linking it to personal, financial, or territorial interests demonstrates an appallingly naive understanding amongst a group of so-called professionals of the political process by which any regulation comes to be implemented. The profession will have to learn to keep quiet about all the money it's going to make if it wants anyone with the power to regulate to take it seriously. If there are people who are unpersuaded by my arguments, who still think that we are going to have regulation one day, then I invite them to show in practical detail how all the problems I have described here may be overcome, and how a government may be persuaded that strong regulation is possible and desirable. Until this is done, I call on all my fellow office bearers in AUSIT and industry opinion leaders to cease wasting the time and emotional commitment of hard-working interpreters and translators everywhere by speaking publicly as though strong regulation will come to pass. I would like to describe what I think are the most practical and desirable features of the regulatory regime that the profession should support and work to develop. You can call this self-regulation if you like. That's certainly what the government would like to call it when they don't want to do anything about it. But it's just another name that will end up being touted as the answer without anyone defining just exactly how it would work. Absolute self-regulation can sometimes result in nothing more socially redeeming than self-abuse. Them or us, the question we must focus our minds on is how strong the regulatory effect would be. If self-regulation ends up no stronger than what we have now, then why bother? We already have registration, for example. The AUSIT Constitution obliges us to maintain a register of members, but it has no regulatory effect. The report recently released by Wits Language Link claims to be representative of the profession, but it only sampled interpreters, only in Victoria, and only on the databases of the agencies that supply to the community domain. Not surprisingly, it found many of them unhappy. I question whether this cohort of 140 people is representative of the industry, which properly defined includes translators all over the country and all those working in and for private industry, the military and diplomatic circles. We, the profession, must define ourselves by reference only to the core skill set of an interpreter or translator, without reference to a particular domain, mode or field. This makes us a much bigger group of people, with expertise and experience from a much wider range of business and social activity, and the sharing, testing and coordination of all the knowledge derived from that experience is the foundation of power. We must not support policy that would alienate any significant part of the profession defined in this way, at the risk of diminishing that power. Indeed, we must ensure that full participation in a comprehensively defined professional life is made appealing to interpreters and translators working in every conceivable field and setting. Thanks to the amount of work in the community domain, training and accreditation in Australia is based on the core elements of translation and interpreting, which are accuracy, faithfulness, and ethics. This has been a very good thing. Work in the business domain, on the other hand, teaches people how to satisfy customers on a job-by-job basis by virtue of their specific performance rather than their credentials. The assumption that the two domains are serviced by discrete groups of practitioners is a myth and must be challenged. The two adjectives community and business do not apply to people or languages, but only to types of work. The industry in Australia has benefited enormously from the interaction between the community and business domains, either in the form of individuals who work in both or by individuals who work in each participating in common professional dialogues, such as meeting via AUSIT, publications and attending biennial conferences. Interpreting and translation are complex and challenging tasks, which done well reward and affirm the individual emotionally and intellectually, rather than just financially. Interaction between all such people should be inherently rewarding, and AUSIT must continue to promote this view in order to attract members. Unfortunately, there are still many people calling themselves professional who don't join AUSIT because it wouldn't make them any money. Basing our membership drives on the potential financial rewards to members would cause us to flirt with commercial interests, completely thwarting our role as objective arbiters of professional standards, which is the one thing we must defend vigorously if we are not to cede industry leadership to other parties such as agencies or the government. The proposed practicing member category of membership in AUSIT is a critical step in establishing a regulatory regime. It rests on several assumptions. The first is that the more you do of something for people who control your income, the better you will get at it, or you will have to stop doing it. Notwithstanding the passion of some AUSIT members for disputing this, something I think is self-evident to most people, what is indisputable is that the market will place as much, if not more, weight on this as an indicator of quality than they would on any credential. What is further not open to dispute is that many practitioners know the market thinks this way and would like to advertise the fact that they have been practicing and satisfying customers regularly for a long time. The current membership categories of AUSIT are completely silent on this issue, and so membership in a professional association currently has very little regulatory effect indeed. If our practicing members were also obliged to be educated, tested, accredited, engaged in ongoing professional development, and to not offend any code we might endorse in order to qualify as practicing members, then it starts to acquire some serious regulatory effect. That is, of course, if any of the people in the settings I described above take any notice. Which brings me to the last mechanism that I think is critical in a regulatory regime for our industry. We want all translation and interpreting work in community settings to be the best quality available, and we want the people who control those settings to be completely accountable for that quality, and we want them to pay whatever it costs to obtain that level of quality. Let's think laterally. What else do they spend lots of money on, and how did they come to do that? They are driven by knowledge and fear. Knowledge of the true cost of neglect or omission, and fear of the consequences. We are verbose in our criticisms of how others don't understand us and our true value. Is it any wonder they don't possess this knowledge yet, and this fear has yet to possess them? It's because we haven't told them. We are the front line. We are the only ones with the ability and the motivation to do this. It is up to us to do the research and collation of all the basic data necessary to put dollar figures on the cost of not having a competent interpreter in court or by the hospital bed. With the current rise in insurance premiums to guard against litigation and professional liability, these figures are growing all the time. And until a decision maker sees a dollar sign, they do not understand what they're meant to do. I think it is one of our highest priorities and will form the basis of the most powerful regulatory mechanisms that we alone can control. I must close by disappointing everyone again. I have ended up by talking about the things I always talk about: data collection, objectivity, and the duty of a profession to society. These are the possible and desirable things that only we can and only we must do.